Okay, we good remember.
Okay, I'll call the meeting to order at 6:36 p.m. and I'll turn to Eric to take the roll.
Chair Cash Parker.
Here.
Vice Chair Matt Crabtree.
Present.
CJ Cullinan. Melinda Ellswick.
Here.
Lauren Cooper. Currently absent. Joe Frigola.
Here.
Ken Chu.
Here.
And then for staff, there's Eric Sampson with Community Development and Sergio Renteria with the City Attorney's Department.
Great. That'll take us to approval of the minutes from the January 17th, 2024 meeting. Is there a motion? Is there any discussion or is there a motion to approve those minutes?
I move.
Matt Crabtree moves to approve the minutes from January 17th. Is there a second?
Second.
Second from Ken Chu. I'll just do voice vote on this if that's okay.
Sure.
Eric, all in favor, say aye. Aye.
Aye.
Aye.
Aye.
I abstain. I wasn't here.
Okay. Abstention by Ken Chu and ayes from everyone else. Good on that, Eric.
Yep,
Okay. Public forum. I don't see anyone in the room from the public, the community. I don't see anyone on the Teams meeting. Am I right about that?
You are correct.
Okay. That will take us to new business. And the first order of new business is an introduction of our new member. Joe, if you want to introduce yourself and tell us a little bit about yourself and what brought you to the Historic Preservation Commission and how long you've been in Inglewood and anything else you want to share about yourself.
Okay, well,
Is that a glitch?
Looks like we're good now.
Yeah, looks like we're good. Go
Go
ahead.
ahead, Joe.
okay, my name's Joe Frigola. I was born at a very young age. I've been in Inglewood for a little over 3 years now. What brought me here was an email that was sent out, and I noted the Historic Preservation Commission, which I bought a 1936 cottage here that I've been renovating. So it's of interest to me. I like to see things preserved, buildings preserved. So thought I'd like to volunteer, and here we are.
Yeah, great. Well, thanks for joining us. And, you know, you'll get kind of, I guess, thrown in the deep end as we go through our business, this meeting and others. But this commission is relatively new. I don't know what the city council said during the interview process, relatively being a relative term. So it's been around. You're original to it,
Original,
Matt?
right.
And it started, remind me of the year,
2017.
2017.
Exactly, 2017.
Yeah. And Melinda's original to it as well.
Yep.
I have been on for 4 years or 5 years now. Ken, you've been on the commission
6
for
months,
6
7
months.
months,
Yeah. So you're not the
Okay.
you're not the junior member anymore.
You're welcome.
Yeah. Your seniority comes with no privileges whatsoever. You moved up the ranks. And until recently, until the passage of the revisions to Title 16 in the fall, the Historic Preservation Commission did not have a lot of actual power to do anything, I think it's fair to say. And so
Pretty much.
we all on this commission have spent a significant amount of time suggesting revisions to the code that were ultimately mostly enacted, where we actually have the ability now to grant landmark designations to historic landmarks and districts and other things like that. So one of the items tonight is going to touch on that pretty significantly, which is the next item of new business, the city attorney's office presentation with some of our new powers that have come to us with the passage of Title 16. But yeah, welcome. I don't know if I missed any other pertinent background. I'd certainly invite any of the other commissioners to offer up anything else that they feel I missed about our fine commission.
Yeah. Do you want to go around the table and kind of introduce ourselves?
Sure. Yeah, and I can start just with myself personally. I'm a Colorado native. I was born in Longmont. I've been in Inglewood for 7 years now. So I've been in Inglewood for a little bit, and my wife and I really like it here. I live just up the street from here. It's a very nice community. I've enjoyed being on this commission and meeting all the folks and working with all the folks on this commission. So that's me. Yeah.
Matt Crabtree, I've lived in Inglewood for 20 years now. Bought my first house here, expecting it just to be, stepping stone. I'll move to something else later on. And I love the neighborhood so much, like the city so much, I stuck around. So now raising a family here. And I'm also president of the Historic Inglewood, the nonprofit preservation society in Inglewood. And professionally, I'm an engineer.
Our commission has to have, by the code, 2 or 3 members who are from historic Inglewood. Is that
Sure. And that is an accurate thing, and we need to actually look at that because CJ's no longer on the preservation board, the Historic Preservation Society. So we probably need to get somebody else from the society.
Yeah, we'll put that, I'll make a note, we'll put that on new business next month. We can discuss that, or we can do it in commissioner's choice. Oh, and yeah, I guess.
And Lauren's Inglewood.
Hey, Lauren. I didn't say what I do
Hey,
professionally.
everyone.
I'm an attorney and I practiced law for 15 years. I just stopped practicing law about a month and a half ago, and I still work with lawyers. I'm the executive director of the National Association of Railroad Trial Counsel, and it's a nationwide group of people who represent railroads like I did for most of my time in private practice. And one thing that I'm very excited about is one of the perks of my job is I got to pick where the office is, which it is now. The National Association of Railroad Trial Counsel is headquartered in Inglewood in the Wells Fargo building right over
Very
there.
good.
Yeah.
There's a lot of history with railroad too.
Yeah,
So, there's
absolutely.
a lot of history and tradition there.
Absolutely. So that was cool that I got to bring the business to Inglewood, the national headquarters, which is myself.
That is
Ken, you want to introduce yourself?
Sure, I'm Ken Chu, and I'm no longer the newest member of this committee.
Congratulations.
My husband and I moved here about 3 years ago, two years ago, a little over 2 years. I work in the affordable housing field, so I work for a congressionally funded nonprofit that funds communities that are developing affordable housing.
Cool. Very good. It's Melinda. I'll look to you next, and I mean you have the best job of all, which is none.
Because I'm retired, you mean? Yes, I'm retired from the state. And I'm a longtime volunteer with Habitat for Humanity. So affordable housing is one of my hobby horses. And I have a 1915 arts and crafts bungalow, which kind of got me started into architectural history. I'd been into Colorado history a great deal before that. But now I'm looking at the history of housing. So that's me in a nutshell.
Great, thanks, Melinda. And then Lauren, I know you joined a minute late. You probably gathered just introducing ourselves to Joe Fregola, our newest member of the Historic Preservation Commission. So if you want to talk a bit about yourself and your history in Inglewood and your profession and anything else you want to tell us.
Yeah, of course. Well, welcome, Joe.
Okay.
So my name's Lauren Cooper. I've been in Inglewood for about almost 8 years now. And I've been on the Preservation Commission since it started. So what is that, 6 years, I think. And actually this is new to everyone else on the commission. I used to be work as a historian with the Colorado Department of Transportation. And actually next month I will be starting a new position with the Advisory Council on Historic Preservation as their Army liaison. So I'll be working with different Army bases, helping them manage historic resources.
Congratulations.
Thanks. I'm pretty excited about it.
Yeah, and so just to give you a little bit more background on the I guess, Joe, the way the commission works, the logistics. So we returned, I think, 3 months ago to having meetings in person. We were completely virtual for a while, 2 years, 3 years, something like that. The time all blends together with the COVID stuff. We preserved the hybrid option because several folks on this commission have, jobs that take them elsewhere, or, other things that make it, sometimes difficult to be here in person. So this hybrid option, the link is in the agenda. It's available if and when you need it. If you can't be here in person, you can always jump on the Teams meeting, and this has worked pretty well the last 3 or 4 meetings when we've done the hybrid combined. And before we leave introductions, Eric, you have to introduce yourself too.
I'm Eric Sampson. I'm a planner too with community development and also the HPC staff liaison. I've been with the city of Inglewood for 6 years, as of last week, I think. And so I've lived in Colorado for 11.
Thank you.
Yeah.
All right. Well, thanks everyone. And again, welcome, Joe.
Thank you.
Let's jump into the main event of the evening, which is Sergio and the presentation from the city attorney's office. Yeah, I noticed there was a PowerPoint.
So I do have that, if you want to share the screen.
Oh, yeah.
If you want to just take over from this.
And while you're setting up, Joe, just as background for you, there were a number of topics, legal topics, that the commission needed either a refresher or an introductory lesson on. I think that we'd been thinking about or talking about for a while. So that's why we invited the city attorney's office in to give us that talk. So I know there's quite a few things covered in the presentation because I did take a peek at it.
Will that be okay, Sergio?
Yeah.
Okay.
You have the PowerPoint or just a PDF of it?
Oh, I do have the PDF, or I'm sorry, I do have the PowerPoint in my email, if you want me to open that.
Let's,
You should be able to open full screen. Go up to view. Should say full screen mode. Down there towards the bottom. Get it? There it is. And the right and left arrows support, yeah.
right, Eric, we can make it work.
All right.
All right, Lauren, Melinda, can you hear me?
Can you see the slide?
I see head nods. Can you see the slides?
Yes to both of those.
If for any reason you can't see anything or
Yes.
something happens, let us know. Just yell it out. I won't be offended.
And I think I said, it's in the meeting packet too, if you want to follow along there.
Yeah, Joe, no need to write it down. We already wrote it down.
Great.
Thanks for not making us take notes. All right, Sergio, take it away.
All right, so I'm Sergio Venturio I'm an assistant city attorney here, for everyone who didn't know. And we're gonna cover some topics. A lot of you probably already aware of these topics and some new ones because of the new designation of the Historic Preservation Commission. And we'll start out with the fun stuff. Sunshine laws, the Colorado Open Meeting Law. State law requires that any state or local government body discuss public business or take formal action during a meeting that is open to the public. What does that mean for you guys? That means that anytime there is a meeting where you guys discuss business, it must be properly noted so that the public can participate and attend. All right, what constitutes a meeting? Any kind of gathering convened to discuss public business, whether in person, by telephone, electronically, or by any other means. Anything that is part of the policymaking process. What this means is that watch out for sending an email, a mass email to all of you guys. That would be considered a meeting. If you guys all send one email talking about business, that's a no-no. Phone calls, Zoom meetings, any sort of electronic means or meeting in public where you guys all get together and discuss business. So you go, next slide is electronic communications, conversations between a quorum in which any business of the body is discussed or where formal action may be taken is subject to the Colorado Open Meetings Law. And that includes phone calls, Zooms, emails, conversations, and everything we just talked about. Now, does that mean that you guys can never get together ever all together? It does not. You just cannot discuss business if you guys all meet together. So city policy, so the Colorado Opens Meetings Law requires that notice be given for a public meeting 24 hours in advance. But city policy is that the agenda for a public meeting be announced and posted the Thursday before the meeting. So notice to the public must be provided by 12 p.m. on Thursday preceding any meeting or formal action of the quorum will be taken. That's just city policy, but again, to be legally compliant, it has to be 24 hours before the meeting. And it must be clearly posted where a layperson knows the place, date, time, and general purpose of the meeting for public participation.
So that's, if I can just interject on that point, and I think most of the people on the commission, I think, have been the chair at some point, so everyone probably knows this, but that's why I have to give the agenda to Eric a week before is the minimum amount of time so that it can be posted the Thursday before. So if you have agenda items, that's why you have to get them to me via Eric, send it to Eric, he can send it to me, at least, and really more than a week, because the week before is when I have to turn in the agenda to Eric.
Sorry, we're having some problems with the full view there. All right, so what does not constitute a meeting? Chance encounters or social occasions do not count as a meeting. What constitutes as a meeting is 3 or more members. So 2 or more members can get together and discuss business, but anytime that there's 3 or more members, you cannot talk about business. So chance encounters at grocery store, happy hour, restaurant, not an issue, you just can't talk about business. Anytime there's 3 or more members, Colorado Opens Meeting laws come into effect. And then just like the Colorado Opens Meetings law, there's a Colorado Open Records Act, which I think affects you guys a lot less, but just so you guys are aware, Colorado Open Records Act, or CORA, requires that most public records be open for inspection by the public. That means that the public can come to the city and request records of city business. What constitutes a public record? Most writings made, maintained, or kept by the city public officials. That includes writings and those made electronically, including emails and texts. So a email that is sent to the city for business purposes can be subject to CORA and could be released. As someone once told me when I was coming up, don't ever send an email that you wouldn't want on CNN with your yearbook photo next to it.
Or driver's license photo, either one.
So takeaways from the Colorado Opens Act or Colorado Open Records Act, or CORA: the board should take action minutes, uploading packet information, distributing that information. Like today, we uploaded all this information that is open to the public has access to it, and the public can request it. Now the fun stuff. The city, through municipal code, adopted rules of procedure. The rules of procedure that we typically use are Bob's Rules of Order. What are Bob's Rules of Order? They're a simplified version of Robert's Rules of Order, which is an 800-page book, and I've never actually read. But it's a simplified version of rules to manage local government meetings. I have yet to meet a board or commission that has not used Bob's Rules of Order. The general provisions of Bob's Rules of Order are that there's a chair, and recognition by the chair is required to address the body. It's called having the floor. Time limit for the floor is 5 minutes. Can request additional time. A member may only speak once to a motion until others have had the opportunity to speak. No interruptions or side discussions. All motions must receive a second for debate or discussion to begin. But the chairperson can deviate from Bob's Rules of Orders if they believe it's more efficient. Bob's Rules of Orders works with motions. Motions must have a second, and there's 3 types of main motions: privilege motions, main motions, and subordinate motions. And then there's also points. Points of privilege are motions that may be raised at any time. Points of information, which is to request information on a specific question. Point of order, point out that a rule is being violated. Point of appeal, challenge a decision by the chairperson about the rules of order. And point of decorum, review and act by a member. Points and motions must be dealt with in the order that they were presented. Privilege motions, main motions, and subordinate motions. Privilege motions are all points are privilege motions, motions to recess, and motions in their executive session. Main motions are formally presented to the body for an item of action, and subordinate motions are motions to amend, continue to a date certain, or call into question. Now, the reason we all came here today, the quasi-judicial function that the board is now going to undertake. The board is going to undertake new abilities to designate landmarks and designate properties as historic landmarks. That involves people's rights, property rights, essentially. And under that, you become a quasi-judicial board. A quasi-judicial board, here's a really legalese explanation on what a quasi-judicial board is. Quasi-judicial actions generally involve a determination of the rights, duties, or obligations of specific individuals on the basis of the application of presently existing legal standards or policy considerations to past or present facts developed at a hearing conducted for the purpose of resolving the particular interest in question. This type of decision-making is dominated quasi-judicial precisely because it bears similarities to a judiciary function performed by the courts. What does that mean? It means that people are going to present applications to you guys, and you guys are going to act, as the Historic Preservation Commission is going to act like judges overseeing their applications. You guys are going to make decisions on their property rights. Now,
May I ask a question?
yes,
Are we officially a quasi-judicial board in its entirety, or are we being given quasi-judicial authority and we are still a board that is not quasi-judicial? I have a reason for my question, but.
you are a quasi-judicial board when you are exercising your quasi-judicial ability, i.e. overseeing the applications.
So, for instance, we are in the same category as Planning and Zoning and the Board of Adjustments and Appeals.
Yes.
The next slide.
Oh, all right. Well, never mind then.
Tremendous segue there.
Yeah, no, done well in that, I guess. I was curious because if another member, like for instance, a member of this board wanted to join another board, that becomes a problem.
Yes.
When you're quasi-judicial.
Yes, city council does not like to appoint. I need to look at the rule specifically, but I think city council has a policy to not appoint individuals to two quasi-judicial boards. I think you can be on a non-quasi-judicial board, like P&Z, Boards of Adjustment and Appeals, and the Fireman Pension Fund.
Okay. Interesting.
But man, I will look into that.
I was just curious.
There is a rule about that.
Okay.
I don't know if it's only one board, but I believe you cannot be on two quasi-judicial boards.
I see. Okay.
So other quasi-judicial boards are the Board of Adjustment and Appeals, BOAA, and Planning and Zoning, P&Z. And what do those boards all have in common? They all decide property rights.
Okay, cool.
Now, quasi-judicial boards, the commissioners act as judges, applying existing laws to specific facts for applicants at public hearings. Now, what's important about quasi-judicial board is that acting as a quasi-judicial board, there's certain things that must come into play. And that's essentially the commissioners cannot discuss a quasi-judicial matter outside of the public hearing. All decisions must be made within the hearing. That includes ex parte communications is prohibited. It's prohibited in civil and criminal cases, and it would be prohibited in a quasi-judicial matter. And it's designed to protect the rights of all involved parties, applicants, people opposed to it, and everyone that is involved with property rights. Now, quasi-judicial proceedings must be conducted in accordance with procedural due process. Procedural due process is notice and a right to be heard. The due process requirement of neutrality in adjudicative proceedings entitles a person to an impartial decision maker. That means you guys cannot make up your mind before you hear the facts and apply those facts. An impartial adjudication requires the absence of personal, financial, or official stake in the decision that would evidence a conflict of interest. Now, it's important. Now that you're part of a quasi-judicial board, you cannot have ex parte communications. That means don't make up your mind before the public hearing, cannot help individuals through the application process, cannot recommend to owners to seek designation, cannot discuss applications outside of the public hearing, cannot have discussions with involved parties outside of the public hearing. And if there is a conflict, you must disclose that conflict.
Let me ask you a question before you move that slide. So in addition to disclosing a conflict, if you are directly affected, or maybe the way to put it is your property interest is directly affected by an application, would you have to recuse yourself from that decision?
So we'll get to this later, but
Sorry if I'm
Oh, no,
stepping
no.
on your toes.
No, that's fine. Municipal code provides for a code of ethics, which as part of a board, we're all part of. The code does define conflict of interest. I don't have it to the top of my head. I don't want to blurt it out in case I'm completely wrong. But I believe it's financial or pecuniary gain. So if you're going to financially benefit from something, that is defined in code as a conflict. There's also provisions in there about the appearance of impropriety. You may not be doing anything wrong, but it doesn't look like that.
Right. And just as an example situation, I don't think it would be appropriate or proper under the code for someone to vote on their own application for a landmark designation for their home. Is that fair to say?
That would be a direct conflict.
Yes.
We hope that you guys would at least own up to it.
Right, or a particular scenario, which is actually more likely, is like, for instance, Arapahoe Acres.
Correct.
Were to seek designation of the entire area
Yes.
under the provision of the neighbor, I can't remember what it's called.
District.
District, thank you, that was escaping me. So for instance, if somebody lived in Arapahoe Acres, yet there was a district application that was submitted, that individual, if they lived in that neighborhood, could not or should not.
Yes, you would essentially be deciding, you would be the judge in your own matter, which is what we're trying to avoid.
Yes,
Yes.
So yes, if there's a neighborhood designation, yes, that's a perfect example of that. If you live in that neighborhood, you should probably not take part in that meeting or that proceeding.
now you can be present, you just cannot participate in the vote, and you cannot participate in the conversation.
Yes, when there's a conflict, you can still be, you can be present at the meeting because it's a public meeting, but you can't partake in that particular meeting when it comes to discussion, questioning, stuff like that.
That makes sense.
And in that situation, they actually can't even be a part of the application process too. Is that correct?
That's the other side of it, that's interesting.
There's nothing prohibiting.
Sorry, can you repeat that question that Ken just asked?
Yeah, the question was if you were on this commission, can you be part of the application process for a district or a property or anything? And so Sergio, that's the question.
There's nothing preventing someone from using the application process for their property or designation of a neighborhood. But you basically would have to make yourself known that you cannot partake in anything that has to do with that. You can't talk to other commissioners about it. It's essentially, you'd be acting as a private citizen, and you couldn't take part in any discussions.
Difficult.
But in the previous slide, it says that you can't help an applicant through the process.
That's more to mean if someone comes up to you and says, hey, I want to do this, will you help me with my application?
Got it, okay.
Oh, yeah. Can you back up just for benefit, CJ? This is really actually fascinating information here, and I think this answers some of the questions that you had brought up at the previous meeting. Just back up a couple slides here, like for instance, the quasi-judicial part of this. This is basically now that we're quasi-judicial, and I'll certainly not continue to talk here because that's not my area of expertise, sir.
So CJ, if you go back, it's all uploaded. It's all on the agenda packet, so you can take a look. But essentially, now that you're taking a quasi-judicial function, you're overseeing property rights, and as part of that function, you'll be acting as a judge for other people's applications. And as a judge, there's certain things that you shouldn't be
No, why
involved in.
can't we be assistants? Why do we have to be a judge?
Because you're essentially taking the laws of the city, the ordinances of the city, interpreting them and granting people property rights
But I'm
or
also,
denying people property rights.
I'm also going to try, who's gonna help them if we don't help them?
They can, we'll get into that.
Because yours right there said we weren't even allowed to help the applicant.
Yes, so a judge, like you gotta think about it as a judge. A
I
judge,
don't want to. No, seriously. Why do we have to be a judge?
Well, because to have this power, it's the law. Like that is the way the law works.
Yeah. So the board and city council, when it comes to quasi judicial matters, actually doesn't have the final say. What you guys do are final decisions that can be appealed to the district court. And the district court can take a look at what you guys
Can't we
do.
help them so that we don't have to get to a district court? I mean, my first thing, who can help them? Who can help them?
They can contact city staff, they can, I mean, you know, that's what community development is here for. One of the things they're here for. That's the only thing. But they can.
I have a question about the who can help them. So in my mind, referring them to historic Inglewood makes sense since they're involved in Inglewood history, but then some of the members of the commission are also a part of historic Inglewood. So like, how does that work?
So, I mean, it's really a case where people will have to kind of help themselves. If they have trouble with applications or the process, they can always reach out to staff. I mean, for boards of adjustment and appeals and P&Z specifically, people hire attorneys to help them through the process. Attorneys present their cases sometimes at P&Z.
Now, Sergio, the situation here with our,
Next screen.
real fast here, just to kind of elaborate on this a little further, so we have, I guess, better understanding, but city staff is not bound by the same ex parte or quasi-judicial authorities in this particular case as the members of this commission are. Is that right?
Well, I mean,
Like city staff, for instance, Eric, or people in the community development department.
yes and no. So all city staff, including myself and Eric, we're bound by the code of conduct.
But, correct.
But yes, city staff is there to help people through the process.
Right, so that's what I was getting at in this particular scenario, is that, well, if there's an active application in for this board, while we cannot, because we will be basically judging the application later on, while we can't, correct me if I'm wrong on all this is my understanding.
Yeah, no, that's what I'm here for.
Throw something at me if I say something incorrect. Anyway, while we are going to be judging that application, we cannot be involved in that application, but city staff can help them with that application and can guide them through that. Or to Lauren's point, which was fantastic, is that the members of Historic Inglewood that are not on this commission can also be present to help. And that's the partnership that we've been looking for a long time with the board. We just have to stay completely impartial, almost not even think about the individual themselves or the scenario except for just the facts.
So how about if someone wasn't a commissioner and they want to volunteer to help people with this? Could they be given those contact information, that contact information could be given to them?
If an applicant can seek help from whomever they would like. There's nothing preventing an applicant from going and asking anyone that they would like. It's just important that the commissioners cannot help the applicant because the commissioners have to go into every application neutral and decide the matter with the facts presented at the public hearing.
The concern for me is the people that are going to qualify for these applications are probably lower income and or fixed income. They're going to already have some issues with what I think is a $250 fee.
Oh, yes.
And the idea that, we were talking months and months and months ago about what could we do to lower that? Could we grandfather some people in, stuff like that? And to even think that they would hire a lawyer, I honestly think is ridiculous. I mean, forgive me, but that takes money.
Well, yeah, no, I mean, people have, but I mean, a lot of people who present at the Board of Adjustment and Appeals are,
Developers.
no, they're just lay people who want a variance to, I think the last one I took a part in and Eric was there, the guy wanted a temporary garage. And he just submitted a variance.
With
At
the
his hearing.
lawyer.
No,
No, that's what I'm saying. He had to,
no.
you had said something about they would come with lawyers.
Well, some people, like, have lawyers, yes. You can have anyone assist you through the process, but it cannot be you guys. Yes, someone can assist in the process. It can be anyone that the applicant wants, but it can't be the board commissioners.
I mean, maybe this is patting ourselves on the back since we designed the process. I would hope that this process is not so hopelessly complex that someone needs to hire a lawyer. And I really don't think it is. I don't think it's that complicated of a process. I think it's fairly straightforward. You fill out the application, which has pretty clear points on it that you have to set forth, and you explain why is this property of historic significance. I don't think that's that complicated.
No, but when we had talked about it, we had even considered assigning it back. We had considered assigning a commissioner to help that applicant.
Yeah.
Remember?
I remember it very well, but that was before there was clarity about whether this function made us a quasi-judicial board, and it clearly does. Like this, what passed in Title 16 makes us a quasi-judicial board.
And I think it's also prudent for us too, that if we find that the process is overly complicated or overly contentious, it is our responsibility to bring that up and address that and fix the
100%.
problem. If we
Absolutely.
can, or at
Yes.
least advise counsel on it, and then they fix the problem.
Exactly, yeah, exactly.
So yes, with the Title 16 changes, it made the board a quasi-judicial board, and with quasi-judicial powers comes quasi-judicial responsibilities, and part of that is to,
And limitations.
and limitations.
Unfortunately.
With the
Go ahead.
more
Sergio.
power comes with more responsibility.
Well, and Sergio, I was really curious on this too, because like some people do serve on, I don't obviously, but some people do serve on multiple commissions. And that's another limiting factor is now, because I wasn't sure if this was going to be a full quasi-judicial as a result, or if it was just going to have quasi-judicial authorities in a particular area and how exactly, but it seems as though we will be fully quasi-judicial, which, yeah, that even limits, you know, other things too, not just.
Matt, I will give you an answer.
Mm.
I hope I don't forget. I'll write it down.
Oh, yeah, that's fine.
But
And
I
believe me,
believe the rule is you can't serve on two quasi-judicial boards. I think
Right.
you can still serve on one quasi-judicial and non-quasi-arts commission.
Right.
The firefighter pension fund always comes up because no one ever applies for it.
Oh, yeah.
You know,
Okay, cool. No, I was just curious because that was ultimately my question, and just to rephrase for CJ too. I was curious how this all worked anyway.
Is it, I mean, I'm not trying to get off track, and we'll return your presentation in a moment. Is anyone in here on another board or commission?
I'm not.
Yeah.
I know it periodically comes up though, that people do serve on multiple. I was just curious about that. So, yeah.
okay, we'll proceed with the
Yeah,
presentation.
thank you.
I believe this was the slide, but we'll start here.
Thank you.
All right. Don't make up your mind before the public hearing. Cannot help individuals through the process. Cannot recommend to owners that they seek designation. Cannot discuss the application outside of the public hearing. Cannot have discussions with involved parties outside of the public hearing. Not everyone may be in favor of the designation, and the people who are against the designation also have a right to come in and voice their opinion, and you guys can also not engage with those individuals. And must disclose any conflicts that you may have against or for the application. So if there's a financial or personal interest in the matter, you need to disclose that, and that may lead to a conflict. What's important to know is that if you think there's a conflict, it's better to disclose than not disclose. And DJ, I don't know, Matt brought up a point. Can you fill out your own application? Yes, you can.
Oh, because I would think that couldn't work for my historic district.
Well, no, you can fill out your own application, but you wouldn't be able to take part in the proceedings.
Go for it, Matt.
Cannot be a witness at the hearing. Can only discuss the matter at the public hearing. So no talk with the commissioners beforehand on how are you guys gonna vote. Don't meet with the applicants outside of the public hearing. Advise people that you cannot talk about the matter and that they should go to the city website or contact city staff. Due process is denied to parties when there is ex parte communications and conflicts are not disclosed, and then there's the issue of the appearance of impropriety. You may not be doing anything improper, but it doesn't look right to a reasonable person. And quasi-judicial decisions are final orders that can be appealed.
At the danger of getting too far into the weeds legally, I'm not trying to do that. So our decisions or recommendations that city council then acts on, isn't the city council decision what can be appealed to the district court? Maybe I'm wrong. This was never my area of practice or area of specialty in the law.
I looked at the code before we came in, and I believe you can be appealed at both places.
Oh, interesting. Okay.
So our,
Via 106.
so
Understood.
literally our decision does not, because I was under the impression that once we made our decision that it would be forwarded to council and council would vote on that, thus giving them the actual legislative authority over this, or the judicial authority, I guess or whatever legal
Some
term you
authority.
use. The authority over the matter would go to council, and we would simply provide the recommendation. Is that still the case, or do we have the direct authority to approve and deny?
When you go to P and Z, they approve you right there.
We'll get into the code. It actually provides for that.
Oh, okay. Sorry, jumping ahead.
No, you're good.
Because I was with you.
So the code provides for quasi-judicial hearings. Here are the code provisions: hearing procedure, purpose and application, definitions, nature of the hearing, commencement of the proceedings, referral of the hearings, public notice, the date, time, place, public hearing shall be given. And then I took out just one of those provisions, which is essentially the procedure for having one of these hearings. It's spelled out in code 110.27. Rights of participants in all quasi-judicial hearings are here above designated shall be conducted under the following procedures. And all parties and witnesses who appear for the purpose of testifying upon the factual matter shall testify under oath. Cross-examination upon request of interested parties of all witnesses. It will be recorded within 35 days after the judicial hearing. A written decision will be, well, I just found a typo because I believe the Title 16 provides for 45 days. Or am I, that's 45 days to hear the application. It's 45 days
Yeah,
to
so
hear the
I think it's
application.
Before we leave that, those written decisions, is that something city staff drafts and then we approve, or does someone have to volunteer to write those that's on this commission?
Eric, who writes the finding of facts for P&Z and BOA?
Good question. I think Shelley does BOA.
Yeah.
Does he do P&Z?
Maybe. I'm not sure. I would have to know. I just know that I don't think it's any of the planners that do it.
So it is someone on city staff that at least does the draft for
Yes.
approval by
Yeah.
the board or commission. Okay.
I didn't know that. I'm just glad it's not me. Then order procedure of the hearing.
I don't even know how to hang up my phone.
So city code provides for the procedure to basically to have a hearing. Start the hearing body will receive staff presentations concerning the issue before the body, the applicant's presentation of such materials and evidence as if they desire to present. The hearing body shall, upon completion of the presentation of the applicant's evidence, call upon any person present in support of the applicant's presentation, present such evidence. Thereafter, the hearing shall call for presentations of information of evidence for any person who desires to oppose the applicant. The applicant will then be given an opportunity to present any further information on the opposition. Then all documents or other items of physical evidence shall be marked as an exhibit, such identifying symbols as may be necessary to determine the exhibit referred to by any witness or person. And you guys have cash, I'm sure you can help you with that. Rules of evidence don't apply, so I don't have to worry about that.
You don't have a hearsay slide in here.
I couldn't. You got to live it to know it. so rules of evidence don't apply. So that really formal kind of introduction of evidence and hearsay and all that stuff doesn't apply. Then deliberation of votes, then party who appeals, and then, okay, it just gets into if someone appeals and they're paying for the transcript.
So while there are some formalities to this procedure, let me interject this comment. This is massively less formal than anything you would do in, say, a courtroom, for instance. So this is designed to be as simple as possible while making it fair for anybody who comes in and makes an application, or anyone who opposes it, to be able to lay out all the evidence. Like, not, for instance, not applying the rules of evidence, which are extremely complicated and do require a lawyer to interpret and navigate. It lets people just come in here and present whatever they have that supports their case, or folks that oppose it, they can present whatever they have. And as long as it appears to us to be, what's the language, reasonably reliable, it can be relied on to make a decision. So yeah, it definitely has some formalities. These hearings will probably look a lot more formal than our month-to-month meetings do, if and hopefully when we have them, because hopefully some folks do apply for designations, but it is designed to be a lot simpler than something that would happen, like I said, for instance, in a courtroom.
So there's a lot here, but it's just basically do this first, then this,
Yes.
then this, then this, then this. I mean, it could be broken down into just start the hearing, hear the evidence, hear staff presentations, hear the other side, hear the other side again, and then so on and so forth. And if you, I mean, you guys can go and see former P&Z and
Sure.
Boards of Adjustment and Appeals hearings. I mean, they're pretty fast and to the point type of stuff. Each administrative body shall have the right to preserve order during the hearing. Basically means that the administrative body, the commission, has the authority to preserve order and make sure that no one is disorderly or anything, or you can eject that person.
Obstreperous.
That's a great word, obstreperous.
I thought it was important to put this in here to let you know that you just can't have people come and yell at your hearings.
What happens at the city council?
Quite regularly, usually every other Monday night.
Okay, so the code of ethics, it's also in the EMC, the code. You hear just the provisions, purpose, and authority, rules of conduct for board members, rules regarding gifts and gratuitous gifts, appearance of impropriety and discharge, and disclosure of recusal procedures and challenges. Essentially, that last one provides that someone else on the board can challenge another board member to recuse. So here are the provisions. There's not a lot there, but it was a lot to put on a PowerPoint slide. I just wanted to point this out to you guys. There is a code of ethics for the city. It does apply to this board, and it does require recusal if there's a conflict of interest.
So let's say the person got their pass and they said, come on, we're having a party in my house so you guys can take a tour of my house. The answer is no, we can't go, right?
That would be several issues of an issue. It would be an open meetings issue. Probably an appearance of impropriety issue.
Celebration. So sad.
Well, great, you guys have signed up for the no fun zone. Sorry, guys.
So use that now. Let's clarify that, because that's actually a really interesting point, because I'd like to understand that better. Because there's somebody may actually, to CJ's point, they may say, this is absolutely fantastic. My home has been designated as a historic landmark in the city of Inglewood. I would like to invite, a large percentage of the city to attend. We would not be able to, even after the decision is made.
If a large so just, going sideways on that one, if a large percentage of the city attended, I think licensing might shut the whole thing down.
Okay, that's a fair point. There's probably a fire code thing.
Okay,
but in the reality of the situation,
so there would be
we be able to
there would be the
attend
issue of the open meetings laws.
Correct.
Are you guys going there for business? Arguable.
Because it's what brought us all together, thus we were all there, and,
Yeah, so there's an argument that that's a violation of open meetings laws.
Sure.
Not good. There's also the issue of.
So we throw that out, 2 members.
There's also the issue of the appearance of impropriety.
Okay.
To celebrate their success. We can't celebrate their success. I'm sorry, but you see that, right? I mean, we're a small community. We're not a big, I just don't get it. We're throwing everything that Inglewood is.
Well,
I get what you're saying, but as part of the quasi judicial board, there's a lot of things that board members on P&Z and Board of Adjustment and Appeals can no longer partake in as well. Because within the code, there's the rules of ethics, which says that you cannot have a conflict of interest. It goes into the appearance of impropriety to avoid it.
yeah.
So if you grant someone's landmark designation and then you go to their house to have a good time, how does that look to everyone else?
That we're celebrating with them.
Or there were special accommodations made for that individual.
No.
based upon that. Yeah, I don't know.
Not everyone may agree with your guys' decisions. Not everyone may be for landmark designation. Not everyone may be for historic neighborhood designation. And those people's opinions also need to be considered.
So let me throw this one out there, and this may help with CJ with understanding of this. But
Go ahead.
we may reach resistance with Arapahoe Acres, and if somebody decides to designate that district, there may be resistance in that. Nobody, let's put it this way, you can't please everybody, and not everyone gets along.
We already know that.
And there's going to be a percentage of that district that I suspect will probably not be in favor of it. And there may be also a percentage of that district that may challenge this. That is a real world scenario for what you're saying, Sergio, is that you cross your T's and dot your I's because people are going to challenge it after the fact. And if we make a mistake and we communicate in a manner that we were not supposed to, or attend a party or know someone or whatever in that particular case, we might get all the way through the process and find at the end that it's been completely invalidated and we didn't have the authority to do it in the first place because of that. Correct? Or am I
Yes,
wrong?
so doing something, jumping off of Matt's hypo there, if there's a large segment of a neighborhood of Arapahoe Acres, for example, who doesn't want this to happen, you don't want to give them reasons why they can reverse all your decisions. So these rules they're designed to protect what you guys are doing and what the commission is doing. They're not designed to hamstring you and make your life difficult and give you a hard time. They're designed to make sure that the process is fair for everybody involved, for and against a particular proposal, and they're designed to protect your decisions, to insulate your decisions, and no one can say that it was done inappropriately. And we're trying to avoid headaches.
Buttocks.
So all these are in code. The packet's uploaded. I strongly recommend that you peruse them. They're not actually that long. And you guys know where to find the code, right? Municode? Go to the city website and it's just there. Or you can just Google Inglewood Municode. Now, findings of facts. What are findings of facts? Applying facts to legal criteria, the evidence of why an action was taken, and makes appellate review easier. So appellate review is that review when someone doesn't like what you're doing. Findings of fact should explain to the reader how and why the city reached its decision. The document should identify the relevant legal criteria such as statutory standards or code provisions. In this case, under Title 16, it'd be Chapter 12 for you guys. Explain the relevant facts relating to the application and apply those facts as a legal criteria. Here are the provisions under Title 16 where you guys will act now. I would recommend that you guys review that. So findings of facts are important because it's going to identify the relevant legal criteria. It's going to explain to anybody why you guys made the decision. You guys are going to apply those facts to the legal criteria and then reach a conclusion. So essentially, you guys are going to identify the legal, why you guys are doing what you're doing, the ordinance, the facts as you understand them, analyze those facts or apply those facts to the law, and then reach a conclusion. Now, I just took out some of the snippets of chapter 12. Here's 1612.2, which is the designation of a landmark and districts. So it provides for nomination and application, and it provides for a process for the application right there. And then here is the quasi-judicial part, the public hearing. Within 45 days, an application is determined complete within the time frame agreed upon the applicant and the city. A public hearing shall be held by the Historic Preservation Commission. And then it provides what you guys will do. The Historic Preservation Commission should provide notice of the date, time, and location of the public hearing to the applicant, the owners of record, the owners of adjacent properties, and if known, to other persons having a legal or equitable interest in the properties. So that means that you must give notice to everybody, including the neighbors around the area. That notice is given so that they can come in and either support, oppose, or ignore the application. There should be a legal notice. The notice shall be posted on the property's physical location for at least 15 days. I'm sure you guys have seen them for Board of Adjustment Appeals notices. And then the
So you were actually required to put the.
That was, my recollection of that as we worked through that code is the city attorney's office, and I think it was someone other than you, Sergio, said that because it affects property rights, it had to be, it had to be posted.
So that means of the, and it follows probably the same process the Board of Adjustment Appeals does, where you have to, as the homeowner or the person, the interested party, purchase the sign printed with the specific size of font and color of font and posted on a wood board in your front yard.
And if you
Yep.
want it,
Do
you
we
have
have-
to pay
that's the same
50
process?
bucks, right?
Yep, it would be just
How much is
basically
it?
the same thing we follow for, we have a section in our Title 16 code that stipulates the size of the materials.
And how much is it when you guys do it?
I don't know, the
City does.
the
It used to
applicant.
be 50 bucks.
The city doesn't do it. So that, I mean, the time that I had, if you remember, I had to go to the Board of Adjustment Appeals. It cost me about $30 for access printing to print it up. So anyway, that's an interesting thing to know.
Yeah, so in a similar fashion as like the other quasi-judicial boards decide property interests and property rights, same with the Historic Preservation Commission.
Mhm.
You guys are deciding property interest rights, so same sort of stuff applies.
Interesting.
I'm just sitting over here cussing a storm. I don't think we expected. Because like you said, hogtie, yeah, I do believe that.
Right, so the Historic Preservation Commission's review, the Historic Preservation Commission shall review the application and evidence submitted at the public hearing for conformance with the established criteria for designation under 1612.5. For the purpose of this chapter, the Historic Preservation Commission shall recommend approval with conditions, or denial of the application. So you guys can approve with a condition, or deny. Historic Preservation Commission shall set forth in writings its findings or the findings of facts, which will constitute the basis of recommendation. The Historic Preservation Commission may continue the nomination process if the commission finds that additional information is necessary to make a recommendation. If the hearing is continued, a time, date, and place and condition shall be established and announced as present. So if you guys need more information or additional information is requested, you guys could continue the hearing. And then the Historic Preservation Commission shall forward the recommendations to City Council for review. And then the City Council shall take final steps on that. And the rest of the proceedings will be at City Councils. And then they will be, based on their decision, it'll be recorded at the county. And then 1612.5, the criteria. Following criteria shall apply to determination whether a property should be designated as a landmark. So the criteria that you guys would consider, whether the property is associated with an event of significant history for the city, Arapahoe County, the state of Colorado, or the United States. Whether the property is associated with persons significant in the history of Inglewood, whether the property has a distinctive characteristic or type of method of construction, architecture style, period. I'm sure you guys are familiar with this stuff, right?
We wrote it. So,
And we
yeah,
talked
I think
about it a
so.
lot.
Yeah, but no, thank you for.
Yeah, but it's
reviewing
always
it.
good to clarify and for the benefit of our new member here
Yes.
also. So it's definitely good to understand that.
So Title 16 is, I don't know, what is it, 230, 250 pages there?
Yeah, but the HPC section is all.
Yeah, the only you guys need to be interested in is chapter 12,
Okay.
unless you really want to read that stuff.
I mean, it's light reading. It's, probably entertaining.
I mean,
I'm
it's
sure there's
big
a lot of good
font.
stuff in there.
It's, yeah,
Suspenseful.
there's interesting stuff in there, but
Yeah, it's important to know the code.
And then for districts, the following criteria shall apply for districts, whether a district was architectural significance, and then it goes into that.
Did you read that?
Read what? I'm
Did
sorry.
you read the 1, 2, 3?
The 1, 2, 3.
Yeah. It says, that do not contribute to the significance of the district, but the non-contributing elements do not noticeably detract from the district's sense of time, place, and historical development. So where I've always wanted a neighborhood where we just save the facade, that isn't just the facade anymore, right? Is anybody else understanding that?
So to carry that language to sort of an extreme example, what that language is saying and the way that I think we set it up after much debate, I don't remember the particular discussions on that point, is if you have a district that is historic, but let's say there is one home that was built in 2023 within that district, you can still get a designation over the whole district, notwithstanding that one home that does not have historic significance. That's an extreme example, but the idea is most districts probably are going to have elements or structures within them that the whole district retains a historic character, but there may be elements or structures that don't detract from that, but are not necessarily historically significant on their own.
So to tell you the truth, I didn't know that we were going quasi-judicial, just so you know. It just did not hit my head that that's what was happening. And so my whole thing was, oh yeah, let's do this. It's voluntary. It'll protect, the front of your house and it'll whatever. Am I mistaken in reading that once we become a historic district with Inglewood landmark status, that there is some stipulation that may control a homeowner's ability to do something with their home?
Well, so there's, and Lauren, if you heard that question, you may be better to address that. I would suspect, but my understanding is that when you have a historic district, it's not necessarily the quality. Correct me if I'm wrong on this with all of our debate discussions. My God, we talked about this for years. It's not necessarily what type of windows you have. It's not necessarily what type of countertops you have or the flooring that's in the homes, but the home itself largely is retained from the outside to its original character. And it's not demolished, is what I'm saying, or a large
Yeah,
percentage.
but it talks about defined by visual, historical documentation of different associations or patterns of development. So the Pop-A-Top thing, yay, it would stop that.
It would.
But if they wanted to add a room, which I did, onto the back,
Well, I think there's,
it's visually changed.
so real fast, here's a point of information I believe it would be appropriate. So Melinda has her hand up.
Melinda, yay.
Sorry, Melinda. I'm far from the screen in here, so thank you.
Your hand is so
Yeah.
teeny weeny.
Oh, my hand is up, yes.
Yes, Melinda, go ahead.
Because later on in our statute there, we address like changes to a designated property and require a certificate of appropriateness. And so we have addressed that.
Yeah, and that's what gives the landmark designation significance, is that if you have it, you're not going to be able to change the elements that contribute to the historic character, which is what will be approved in our findings of fact and recommendations about that. And so that's why, yeah, I mean, there are bound to be, and Arapahoe Acres is probably a good example, there are bound to be applications that get filed where folks will oppose them for that reason. And that's why we have to be fair and impartial in making the decisions about whether something is entitled to landmark status, because it does impact your property rights and your ability to change things or do things
Sure,
moving
totally.
forward.
And that's the critical part of this, is that it's largely, now obviously district aside, but this is largely a volunteer process. So the homeowner, you know, a forced process or a non-voluntary process was something that I was never going to be personally happy with. But a process where somebody says, my home is really important. It has a lot of historic character in it. I want it historically designated, because if I sell, you know, the scenario that I always came up with is if I sell in 2 or 3 years, I don't want a developer to come in and scrape it. And I lose that, then this heritage or history in the city is lost. That's kind of in my head how this works. But keep in mind that and Sergio, if you want to make sure that I'm correct on this too, please, with what I'm saying here, but because we're quasi-judicial and we have these authorities here, and that later in the code, it does state certificate of appropriateness for changes to the property and things along those lines. Because of our authority that we have, we can go in and we can, you know, somebody will want to do something to the property, and we have the ability to go in and say if that's.
Yeah, that's the flip side of the quasi judicial powers we have, is we have the ability to review and approve or issue certificates of appropriateness
Yep.
if someone wants to make alterations to a property that has been designated as a landmark.
It's never an absolute. So if because I mean, look at this scenario in Arapahoe Acres, for instance, right? So how many homes have been lost in Arapahoe Acres?
6.
And they were, is that lost in the entirety, or is that lost in?
Yeah, like some walls were saved maybe in one, and the other one, it was lost, one wall was saved. So the other one.
With that particular scenario in mind, if it was a historic district, that couldn't be 100% stopped. But there would be a path there to basically provide the judgment, I guess, for if that can or cannot be done almost on our backs. Is that right, Sergio?
Yes.
Yeah.
Because that's the thing.
There is a stipulation there that, for instance, a developer can't scrape a historic house without our approval.
Well, but no, not even Mrs. Smith can't go in and put in a modern bathroom
Not true.
that's handicap accessible.
I don't
No,
think
that's,
And no, it's just exterior,
See the
CJ.
word exterior. Okay. It said visual. I just didn't see it only as.
And this is another thing, like especially with districts, but even with individual properties, like when we're reviewing the nominations, we need to be very specific about what are the features of this building or property that make it significant. Because let's say the windows don't really matter at all. And so if they want to go in and change the windows, then that makes our decision easier. Okay, that's fine to do that. But, you know, maybe the fact that it has wood siding is really important. That needs to be in the nomination, that the wood siding is very important, so that when they go to change it, or if they want to change it, then that's what we're focusing in on, and that sort of thing.
That is a great point, and because we can approve applications with conditions, certainly I could see that being a situation where an application was conditionally approved, subject to more specificity being provided about features that are characteristics that make the property historically significant, because that's exactly right. And not only for our purposes, but the landowner that's seeking the designation, they want that to be as specific as possible, so that if they die or sell the house or whatever, it's very clearly enumerated what you can or cannot do.
Right.
What makes the property historically significant.
And again, CJ, nothing is an absolute. And there's always a process. There's always, and we're just the first step in the process if somebody wants to tear down their house and they've got a historic designation.
So any overarching questions from anybody? Online?
Yeah, I was gonna ask the online folks, Lauren or Melinda, do you have other points or questions you want to raise?
Oh,
I don't think
that was
so.
basically it.
Okay, any more questions in here?
Hold on.
What do you guys think about it? What's important to know is that you guys have a lot of materials. The materials we covered today, you don't have to memorize them. They're accessible. Go to your handbook, the board handbook. The code is just online. Just look it up anytime you want. If you have any questions about stuff, reach out to staff or community development. If you have any legal questions, reach out to me. That's what I'm here for. If you have ethics questions, you can reach out to me.
I do have a question that wasn't covered in here. I think I know how it works at city council, and maybe it's the same here, but if we need to have, well, it's two questions. So maybe you could explain what an executive session is, number one, and two, when we can have it and how we can convene it. That's actually probably three questions.
An executive session is usually to get legal advice. It has to be announced, and we have to provide it in a public notice that we will be going into executive session. Executive sessions per city council policy have to be all in person. I know that the board is hybrid, but there is a policy that they must be in person. Essentially, we would have to announce to the public that we're having an executive session for X, Y, and Z.
What would be an X, Y, and Z for us?
So
That's a really good
I'm
question.
trying to think what an X, Y, and Z would be for us, and I can't think.
So so an executive session, because it's typically or almost always for the purpose of seeking legal advice from the city attorney's office in this instance, that is not subject to open meetings, it is not subject to quora, it is protected by attorney-client privilege.
To some degree. There's actually in governmental, excuse me, I'm not gonna speak to that because we have a lawyer in the room. I'm not gonna say anything.
So
There's exceptions and there's other things but I could see a situation if we're dealing with these applications where we need legal advice that is not available to the public, because if we're not in executive session, this is a public meeting, anyone can walk in off the street right now. We're not discussing, this is educational, this is legal topics, we're not discussing attorney-client privilege matters.
So the issue of the board thinks they need an executive session, we can cross every turn it comes with it. It does need to be announced as a public meeting, so we would put it in the agenda. The agenda would essentially say the board is going to do executive session, and we have to provide enough specificity to where the public knows why we're going into executive session. It doesn't detail exactly why we're doing it. It doesn't detail the legal advice, but it needs to detail so the public is aware why we're going into an executive session. And it does all have to be in person, per city council policy. I don't know if they make an exception for hybrid.
Can I ask a question? This is probably more,
Yeah. Go ahead.
Stepping back from this. Correct me if I'm wrong, but it's not particularly common for boards to have executive sessions.
I don't know of a board that has had an executive session. Do you know, Eric?
Nope.
Yeah.
It's typically not common, and
It's not something I think would be common. I could just see it coming up because since this is a new process and we're a newly quasi-judicial board, I could see the situation arising. It's clearly a matter that's more of city council issue because it's the typical thing, and you can't go into specific examples. Is like, if the city council needs advice about what are we going to do about this lawsuit, are we going to file this lawsuit, are we going to settle this lawsuit? Hopefully that's never a situation we're dealing with here, but I could see.
Well, it's probably taken out of our authority at that point in time. I'm sure city council's getting heavily involved.
Right, but again, I could see a situation where it's like, we need to have a confidential attorney-client privilege situation to get advice on, on how we're applying the code and going through it. That's why I asked the question. I just was curious I assumed it was the same process as council.
so if there's a general question on I guess, the process, feel free to reach out to Eric. If Eric feels that it's a legal thing, he reaches out to us and we'll answer the question. If one of you guys feels that you have an ethical, maybe it is, maybe it's not, feel free to reach out and we can deal directly.
Yeah, because we've obviously never crossed that bridge before, so I just didn't know if the
So if you
process
feel
was-
that maybe it's an ethics violation, maybe it's not, feel free to tell us.
Or if we need to get legal advice in that particular scenario, I think, yeah, I don't know. It's going to be a learning experience for us, I think, the first few times that we do this, and we'll see how things work. I like the way you described it earlier with kind of the flow chart, if then this, type scenario. We'll just, I'm excited to have the opportunity to do this for the first time, and I'm sure it's going to be a really interesting process.
Yeah, no, and my office, community development, we're here for you guys. So if you guys have questions, reach out to Eric, reach out to myself, reach out to both of us, reach out to Brian. Vicky was here before. I mean, we're here to serve.
I don't want to leave this until we make sure that we've asked all the questions that we want to ask. Are we good in the room? Are there any other questions for Sergio?
Can we change any of this? How do
Can
you not
you change
become
any of
quasi?
this?
Like, can you go back and not be
Can the
quasi?
board change it? No. It would have to be up to city council to make those changes.
And even at that, CJ, here's the problem, right? So if we want to have the authority to do these, make these decisions, then we need to have the authority under the quasi-judicial. It's got to land somewhere, right? I mean, the only other, obviously, I think that ship sailed at the moment with the title being and the code being written the way it is, and the interpretation and the way that it has all fallen in place. If city council had that authority, that would be taking away the authority for us. They still have the authority. They can override our decision, but we have the ability to make the decision and make the judgment on the property. And it sounds like you're going to say something.
No, I don't
Probably
mean
a
to
good
interrupt
idea.
you.
Please do. Because like I said, I am simply an engineer, and I've studied a lot about what the city does over many, many, years. So I'm not a lawyer.
What's important about the procedures is that when you start getting involved with people's property rights, the government can't just take actions to come in and take your property away or somehow affect your property rights. So getting into constitutional arguments about violating people's constitutional rights when a government actor, it's like annexing
No, I just
property,
wanted
coming in
someone
and
to
just.
be happy about that they're doing their best to save an 1865 house.
Yeah.
I
Or
just,
1925
that was
is
all I
fine.
really wanted, was them to be happy about that.
They
But
can
now it sounds like we're saying, but you can't do this anymore.
No, I get your point on that. Whenever stringent process and procedure is applied in a scenario, it makes it look very
Stringent and
unfun,
applied.
not very fun. But we have a fantastic community development department here, and Eric will be the one that will probably be stuck with that side of things.
Yeah.
Is
And I
this
appreciate that.
actually in the job description?
And he will, and they will
Well,
be the
not in
ones.
so many words, but there.
Yeah, I believe there's a little asterisk below every job description
It's
that
like-
says, and.
Other duties as assigned.
Yes. But Eric and the community development department will be the ones that will help through the process. We have to stay impartial on this, otherwise we don't have the authority to make or we wouldn't have the authority to make those
No, I
decisions.
appreciate what you're saying. I just didn't think it'd be so far-reaching. I just didn't. I really thought we were gonna put a little black on somebody's house. I mean, oh my gosh.
Well, but it's good that it's far-reaching, and you have to have this process for the landmark designation to mean anything. Because if we approve one, then it actually restricts what people can do as far as changing the historically significant character of the property. Versus if we didn't have this process, we can put a plaque on whatever we want, and from a preservation standpoint, it's
What does that
worth,
mean?
it's worth what the plaque is printed on, because people can do whatever they want. This actually gives us teeth, but the process has to go behind it. And the other thing that I will say too is city council, while they can approve, deny, or modify our decision, the way the code is set up, and we've spent hours and years working through this, the city council is essentially delegating through the code to us the power to hear all of the evidence. So we're the ones that hear the witnesses, people who testify under the oath. We're the ones who see the pieces of paper, the documents that people bring in supporting their designation. We're the ones who hear from the opposition if there's opposition. And so we make that decision and recommendation, and we have that function because city council just looks at what we put together in a written decision and then either approves it, rejects it, or modifies it. If I misstated any of that, Sergio, tell me.
One last thing to add, the other benefit with the process is that it also gives us boundaries as to where we can go up to. Meaning the clarity of the application and everything, we're forced within a boundary of here to here. And we can't promise something special, we can't do something special because it's not part of the process. And not to say that any of us would do anything that would be outside of that level of acceptance. It's not to say if there's somebody in the future that would promise something special in these particular cases, that would not be allowed per the rules. So it's basically framing us into being decision makers, being the managers of the situation, providing the recommendation to city council.
Anything else from folks in the room? Questions or comments? Hearing none. Lauren, Melinda, folks online, any questions or comments?
None for me, no.
Not for me either.
Wonderful. Sergio, thank you for putting together that presentation. Thanks for your work on that. And thank you for spending a bunch of time with us, not just tonight, but tonight as well. So thank you very much for that. That was very informative, very helpful.
Anytime you guys need anything, just reach out.
Appreciate
Thanks,
it.
Sergio.
Appreciate it. So that'll bring us to our next item of new business, which is election of officers. And do we have to do it tonight, Eric? I'm going to turn it to you to tell us what we have to do.
I would prefer to do it tonight since
Okay.
we have a full house. We have everybody here. So,
Yeah, you're right. We do have everyone. It's true.
so I would definitely say we can probably get through this real quick. I just need nominations for chair and vice chair. We can have some discussion, but I will need a nomination and a second to then a vote.
I would like to see Kat.
I will enter something.
Go for it.
I will nominate Cash to remain chair for a second term.
Oh, well, thank you. I appreciate that.
Yes, I was just, you beat me to it, Melinda.
So-
You literally-
Okay.
Yeah, so Melinda made the nomination. Matt, do you want to make it a second for
I will
Eric?
absolutely second that. You've done an extraordinary job as our chair.
You have.
You all are too kind. So thank you. It's not the pay. I do the job.
There you go.
That's a given.
Do you need to do a roll call vote on that, Eric?
If we can get both the nominations together. I just
Sure.
Oh, do
Okay,
it.
and then just some, I will nominate Matt Crabtree to continue. I believe he's still eligible as vice chair. Is there a second for that nomination?
Second, CJ.
Thank you.
No, thank you.
And so who would be my move on that? For
Was
the
it Cash?
first?
I wasn't allowed to.
But yeah, but Melinda was the first for the,
Melinda was the
I'll
nomination.
oh, the nomination.
Matt was the second. I nominated Matt for vice chair. CJ was the second. Does that give you what you need?
Gotcha. I think so.
Maybe they call it a slate.
Yeah.
If we would have done a slate, that would have been different. Oh, well.
Do you want a motion to approve the slate? I think that's probably the parliamentary.
That's what I would.
I
Yeah,
parliamentary
that's what I
correct
like.
way.
Yeah, so like a
I
motion
see.
to approve Cash as chair and Matt Crabtree as vice chair.
Go ahead.
I so moved that we approve the slate of Cash as chair and Matt as vice chair.
So that's moved by CJ. Is there a second for that
I'll second.
motion? Second by Ken Chu. And then you just want to call roll
Sure.
to make that easier.
Let's go down my list. CJ,
Yes.
Matt,
Yes.
Melinda,
Yes.
Lauren,
Yes.
Cash,
Aye, yes.
Yeah.
Joe,
Yes.
Ken.
Yes.
All right, unanimous.
All right, well.
Yay!
Continue on.
Yeah, we'll continue forward. All right. Thanks,
Aren't you
Eric.
glad you didn't have to spend anything on signage?
Oh, yeah, I mean, campaign signs are expensive. Ask me how I know.
That brings us to old business, and Councilmember Wright is not here. So I can't remember who was here last month. It's been a very busy month because I started a new job a month ago. But yeah, thank you. Councilmember Wright is our city council liaison, and she was here last month. And she had mentioned that Councilmember Anderson was doing town hall meetings regarding Title 16. I don't remember more details. I should have written more in my notes, but I didn't. Does anyone else have any detail on that or no?
Unfortunately, I really don't know. I don't even know what's going to be. I know that there's been discussions on it occurring. It might have already.
Yeah, it happened
already.
last night, I believe.
So we missed it. We missed it.
Were you there?
No, I wasn't.
Eric, I don't know if you have the ability to inquire of council or have Brian or Isham or someone else inquire of council whether there's plans to do further meetings on Title 16, because, and here, Sergio, you can come in on this too. If it's a public meeting where we're giving education or training or explanation of the process without recommending anyone do it or anything like that, that's perfectly fine for us as, for a commissioner or members of the commission to be doing. Is that correct?
If you notice a public meeting where, say, for example, the city attorney or staff are gonna give a presentation on the entirety of the process, that would be acceptable.
Yeah.
So
So,
essentially a meeting where we're gonna talk about Title 16, Chapter 12.
so Eric, I have no idea, and if anyone else does, please chime in about whether there's any further, whether there's plans by the city to have sessions on that or anything like that.
I could.
Why don't we do our own?
Yeah, I mean, that would be
I mean,
a good thing.
springtime, I don't know when the deadline for the city newsletter, the nuclear magazine or whatever that goes out, but if that could get published in there, if you have
We
questions.
just
about
got it, so it must be
Probably,
a couple more
was it
months.
3 months or so, but I don't know when the deadline for publishing the next edition, but if we could, I mean, obviously this is going to take a more formal action than just us talking right now, but I think it'd be pretty cool if we had like a town hall at maybe the community room, and talk about what historic preservation is, what the benefits are, how it's being governed by way of Title 16. And, we obviously can't encourage per our quasi-judicial discussion. However, we can provide general information on it, right?
Yes.
Would that be acceptable for a commission to have a town hall meeting? I don't think that's ever happened, but.
I would point it more towards something like tonight where a training is provided. Like we could present on the entirety of the Title 16. Or Chapter 12.
That affects.
Not the entirety
Yeah.
of Title 16, no.
Would it be?
Yeah.
Well, we'd get a lot of people there, probably.
Yeah.
That would have opinions.
Yeah.
But it would be like a regular meeting where it's public comment.
Yeah.
Then process and all that.
Yeah. So that addresses the logistics of having the meeting. Eric, if you could, and I'm not suggesting, we'll have to discuss this again next month. I'll put it on old business. If you could talk with the folks in communications maybe about how we could go about marketing such a thing to get people to come to it, because we very rarely have members of the public come to public forums. So I think I think it's a fantastic idea. I think it needs to be marketed a little bit by the
probably.
city.
Now, just to clarify, like I said, I've never heard of planning and zoning having a town hall meeting. We have the authority to do so, right?
What about like what we did with the neighborhood map when we set up at the library and had people come? Could we do something similar to that? Maybe, but just with maybe a more formal presentation as part of it?
There's nothing that prevents the commission from having a meeting outside of the civic center as long as it's in compliance with proper posting.
No, it would be in the civic center
It
probably.
would be in the civic center,
Yeah.
but still, it would have to be
Right.
part of,
It would be-
it would have to be noticed.
It would be a special meeting, and, you know, it wouldn't be one of our regular meetings, which, you know, we have to, I think, vote on approving a special meeting and all that, but no, we can have a meeting anywhere we want. I mean,
Sure, yeah.
yeah.
Because my thing would be, what is, how did we do it?
But yeah, like I said, it's gotta be marketed, since we don't tend to get folks at our regular meetings, so that piece from comms, if there's to talk to them about how they might go about doing that, so that we don't have the meeting and just have to talk to ourselves, as fun, as fun as that is, but we get to do that at our regular
We got
meetings.
used to that.
Yeah, good, sounds good. Then the next item of old business is, speaking of marketing landmark designations, the landmark designation letter that we redlined it, and then it went back to communications and back to Sergio, I think your office for comment one more time. And Eric, I believe this version that's in the packet reflects all of our changes and all of the city attorney changes, and all of the communications changes, is that right?
That is correct. Yeah, the last one I went to was communications, and they just applied the city style guide.
I think the only thing that changed was the QR code.
Yeah. Can you show this on the screen, Eric? Do you have that ability? If not, no biggie.
Just gotta get to the agenda real quick.
While you're doing that, if we have no further changes, do you need just a vote to approve this, to send it out?
Yeah, I just want to do that to make it official.
Yeah.
And that's going out to all those properties on that Excel spreadsheet, correct?
Yes.
Yeah.
So there was a property that was not on that Excel spreadsheet that is in this neighborhood here that Melinda and I were talking about. That's probably not historic, but it has an observatory.
Oh, I think it is, I know exactly what you're talking about, it's right down the street from the depot.
Yes.
Yeah, I totally know what you're talking about. Actually, I think, well, probably I mean, that's the question, historic in age versus historic in character or event. But if it's older than that.
The house is definitely historic. I mean, it's more than 50 years old. The observatory dates to like 2006.
But it's a fascinating house you don't normally see. There are a couple homes in Denver that have that. I believe there's another one down in the Washington Park area that has one, but it's very unique to have that in Inglewood. It's amazing, actually. It's really cool. You drive past
Can
that.
we designate to send a letter to them? Even though they're not on the Excel list?
I mean, I think we could, I don't, personally, I don't think there's any reason why we can't, right? There's nothing that says that we have to do it just to the list. We can do that we can send this letter to anyone that we come across.
What do you think, Lauren? Did you hear that the observatory was put in 2006?
Yeah, I was just gonna ask, where is this house? Because it sounds
prop-
really amazing. I
Do you
don't
know where
know.
the community, do you know where the community garden is?
Yeah,
There at the depot?
Yeah, it's.
Yeah, it's on Fox is where the
Yeah,
Okay.
it's
The
on
house
Fox.
is.
That's exactly right. It's like just half a block up from that community garden.
On that
oh,
side?
interesting.
On
Okay.
the same side as the garden. It's huge. They have an observatory and they're really nice people, but it's really beautiful.
I asked a stargazer friend of mine if she knew the guy, but she didn't. But she said she'd like to.
So really the only changes that communications made was differences in some capitalization and punctuation, and that is it.
There's an extra space in that paragraph right there
Yeah.
where it says for more information. Right at the beginning.
Yeah, the word "for" is not left justified.
Oh, right there, okay.
Yeah.
Isn't there a comma?
Is there a way you could share your screen so we can see it too?
Oh, yeah, sorry, I thought everybody, I'm sorry. There we go.
Is that a comma after dear?
Communications, put it there. I don't.
Well, I say
I've never
communications
seen
is
that,
wrong.
but,
Let's take it out. I mean, to me, communications doesn't mean that it has
well,
to.
then it needs to go back to communications.
Oh, come now. They make mistakes too, you know?
What happened? I missed what you said, CJ.
The comma after dear.
Yeah, I would not write that. I agree. I don't want to have to wait another month to do
I
another
know,
vote to send
that'd
it
be
back to
silly.
communications.
I mean, I can ask Chris if that was a typo on his part, and if so, I can just amend it.
Can I raise a motion to have the comma removed after deer, and then it's seconded, and then it happens?
I don't know, can we do that?
Yeah, I'm sure we can do that.
Does that mean that we have to wait again?
No, okay, I mean, can't we?
Probably.
I think you can make a motion with a condition.
Yeah, can't we make a motion and have a second with a condition to correct the typographical error of that comma after deer and that extra space on the word "for" in the second to last paragraph? And then.
And there's also a period missing at the end of the first paragraph after landmark designation.
My gosh, you're right.
That is
Yeah,
also
okay.
correct.
So yeah, you can make a motion to say like as amended.
Yeah.
CJ so moves that the letter is accepted for mailing to Inglewood citizens with the condition of.
Of three typographical modifications,
Uh,
deletion.
Sorry, I just saw one more. Also at the end, also at the end of that first paragraph, landmark is capitalized, but it's not capitalized anywhere else. So we just need to make that lowercase or make them all capitalized.
I swore we told them last month to make that change to it, so.
I'll keep it all capitalized.
Well, that's one of the things that communications did change, because they were decapitalizing things that I thought should have been capitalized.
I also did agree with some of their changes, but
Didn't?
final say.
I thought we did have the final say, but I guess we don't.
Well, I mean,
Yes, there was a wee bit of sarcasm there.
I don't know, to your point, CJ, I think that if we make a motion that, you know, we're approved, because at the end of the day, communications is not necessarily the authority to vote on this. They are the authority to make sure that this falls within the guidelines of the city, right? The communication style of the city.
Yes.
Which one is it?
This A, eyes to surface.
Mm,
A is not
space
left
before
justified
that.
either. So let's just, what I'm proposing, Eric, is I'll make the motion. We'll make a motion to approve it as amended, and it should go out with the changes that we're suggesting. And it can, like, I don't want, I don't want to see it again on the agenda next week.
Yeah. Okay.
Does that make sense?
Yeah, yeah, so you guys do your motion, approve it, I'll run it by everybody I need to run it by, and if you're
Okay.
cool with that, then we're cool with that.
So for the record, we'll state each individual.
Yeah, I'll do
Okay.
it.
Okay.
So I'll make the motion to approve the landmark designation letter as amended with the following changes. Remove the comma after deer in the salutation. Landmark at the end of the first paragraph will be made lowercase to match the rest of the letter. Period will be placed after the word designation at the end of the first paragraph in the letter. In the third paragraph, that will be left justified, i.e. the space before the word A will be removed. And then in the sixth paragraph, that will also be left justified. in the space before the word "for" will be removed. And that is my motion to approve this as amended so that it can go out following this meeting. Is there a second for that
CJ
motion?
seconds.
Okay, the second is from CJ. Do you want to take just a roll call so it's in the record, Eric?
CJ,
Yes.
Matt,
Yes.
Melinda,
Yes.
Lauren,
Yes.
Cash,
Yes.
Joe,
Yes.
Ken.
Yes.
I think that's it.
All right, that motion carries. And well, I'm excited that the letters.
I don't know if anyone can see the screen I'm sharing.
We can
Yeah.
see it.
Yeah.
Yep,
That's-
the house with the observatory.
That is so cool.
Yeah, that's pretty amazing.
Eric, if
Yeah.
I could,
Architecturally
adjust the letter to
significant.
them, that'd be
Just
great.
kidding. If you want to just email it to me.
I'll email it
And
to
I'll
you.
just add it to the list.
Yeah, excellent.
Well, she probably knows the address right now. Melinda, what's the address of that house?
It's on Fox.
Never mind. Okay,
South.
because I mean, architecturally significant.
It's very cool.
It is super cool.
I live just 2 blocks.
I mean, it looks like
Oh,
it's,
cool.
really? So you've gone over and gone in it,
No, I haven't been inside of it, but we talk to them all the time. They're really nice.
and you haven't asked to go inside. You're amazing.
I wouldn't want to ask. I'm hoping they'll invite us. If we're nice enough, I think they'll invite us.
You can just tell them, hey, we saw your picture at the Historic Commission. It'd be cool to see what it looks like.
Okay, that is the end of the old business. So we're approaching our time here, but we're almost to the end. Staff's choice. Eric, do you have anything for staff's choice?
So Monday night, council voted to approve the amendment to the neighborhood map at Hampton Hills,
Yay.
moving it over street. So that was approved.
That
Yeah,
happened
great.
pretty
Thank,
quick.
thank you for the update on that. I took that off the agenda because it just, we had it on the agenda a couple times. It didn't seem to need to be an agenda item. Anything else for staff's choice, Eric?
That is it. I will be out next month, but somebody will be here in my place.
Got it. Brian, probably, I assume.
That's my assumption.
Commissioner's choice, I'll start and then I'll go around the room. I just happened to see, again, because my new office is in the Wells Fargo building, that a neighborhood sign was put up right across from there. I can see it out my office window.
For Hampton Hills.
No, what is that neighborhood? It's right across from the Wells Fargo building.
Cushing Park.
Cushing Park, yes, that's it. So they were out yesterday putting up a sign, so I thought that was cool.
Very good.
Yeah, so that was neat. I'll just go around the table, and Commissioner's choice, Joe, is just, it's your choice. You can talk about any topic or topics if you want. Do you have anything for Commissioner's choice this evening?
I do not.
Okay, great. Well, welcome again. CJ.
The next lecture is this Tuesday, and it is on mid-century modern architecture and what makes that kind of interesting. And then the month after, and that's by Adam, he's an amazing member of a national chapter, of a local chapter of an international thing that recognizes mid-century modern architecture. And so that is at 2:30 here at the library or 6:30 at Table
Public House.
Public House.
That's at 2190 South Platte River Drive. I actually
Yeah,
have an
it's
update
really
on it.
cute.
It's really cool.
And then in March, on the last Tuesday of March, we're doing Diane Ray Tomaso, an internationally renowned historic preservationist, will also be giving a lecture, but it's specifically about Arapahoe Acres. So just wanted to make sure that it is at those two places again, library and then the tavern or the public house. And then this is, I think I've already said, is our 75th anniversary for Inglewood, for Arapahoe Acres. And we planned some tours and some walking tours and a really cool neighborhood night out for our neighbors. And so that'll be one of those, I just think it's gonna make it a fun year. And we're going to be able to honor Diane Ray Tomaso at a function here at Hamden Hall.
Cool.
And show some of the archival things that we have that haven't really been preserved archivally that we would like. So, to show off. Anyway, that's it. I'll get dates for you.
Thank you. Ken, Commissioner's choice.
Oh, nothing for me, thank you.
Thank you. Matt.
Okay, so as CJ had brought up, Tuesday, February 27th is the lecture. We've actually had an overwhelming response from this. We have the Eventbrite for both the library and the evening presentation have sold out.
Oh,
They're
shoot,
free
I didn't
events.
even do it.
They're free events, obviously. It's more or less we just track how many people. Sometimes we have 10 people show up, sometimes we have 100. And we're, good problem to have, but we need to make sure that we provide appropriate accommodations. And anyway, we've had a lot of response on this. So if you do want to go, let me know. We'll figure something out. But this has been a really, really
I'll
exciting.
apply to be a waiter there for that night.
There you go. And again, that was 2:30 p.m. Inglewood Public Library, 6:30 p.m. Table Public House, 2190 South Platte River Drive. Yes, absolutely, it is in Denver. It's a really cool place. The problem is we've bounced around a few different places here in Inglewood. We're trying to find a place in Inglewood again.
Have you ever talked to Sales, or he who owns the Inglewood Grand, about doing it there?
The space,
Have enough
Not enough
space.
space there.
tried, actually, it's a great place. It would be a perfect place because that's a historic building, obviously, in
And
itself.
Phil
but-
lives in Inglewood.
Yeah, oh, totally,
Oh.
yeah.
What
And-
vulnerability?
We used to do it at Brewerville. It was on Broadway at the time, and we did it there, and it was a really good space for it. Unfortunately, when they changed ownership, their focus kind of diverted elsewhere. So we then did it at Moe's. Moe's was a pretty good place, but parking was an issue. So anyway, we bounced around a few different places around England. Another thing, I have a question on the amendment to the neighborhood map. There was a question, I wanted to clarify this, that it was only that one street that was changed, i.e. it only expanded over one street. It did not change anything as in removing any other areas.
Correct, yeah. It was just that one.
Okay.
We were, if you recall, we really
We
parsed
did.
the language to
We
make
did.
sure it covered only the
I was
area.
more concerned on
Yeah.
the back end side where it was approved by council, because there was a few questions that came up as a result of that.
Yeah, and I think, so that's a great question. So I put together the written record of our resolution, and I was very, very careful because I knew it's what council would do to pass it,
Very
so.
Cool,
Yeah.
perfect.
Thank you.
And then the third is, and a lot of you have not seen this, but we can pass this around the table. This was the prototype for the historic landmark plaque. The cost of materials has gone up a lot. That is made of solid bronze. When I made that prototype, God, I don't know how many years ago, 4 years ago-ish, 5 years ago?
I can't show, oh, here, can you guys see that?
Oh, well done.
Ooh.
Don't drop it on your foot. I
No.
wouldn't worry about the plaque, I'd worry about your foot.
And we've seen it before.
So I'll try to have an update next meeting. I'm gonna go around to a couple of metal suppliers and see what the cost of the materials are now. As this is 3/8 inch bronze, which this was made out of a piece of what they call drop. So this was like a cutoff piece that they were selling at a discount. And I thought we could continue to do that to save the city a little bit of money. But with just raw metal, non-ferrous metal value going up as much as it has, this is probably considerably more expensive to manufacture in this particular sense as this
And
thing.
what about the idea of going resin?
So resin will not hold up to UV, even though there are
Oh,
UV
that's
stable
what it
resins
was,
out there,
UV.
but resins just won't hold up in ultraviolet scenarios for very long. And whereas this has a sealant on it, but eventually it will patina.
Yeah, and thank you for doing that, and thank you for looking into that. I'll put that on the agenda next month, if
yeah.
that's okay with you.
Because I'm thinking instead of 3/8, we're probably gonna go maybe a little bit shorter, whatever, we'll figure it out. A little bit
1/8.
thinner. Well, yeah, I don't know, that's an 1/8 inch cut there on the top there. And I will say also that we probably should consider finding somebody to do this professionally. I will make some of them, but making these for the rest of my known existence is probably not a good idea. There's manufacturing, they have supply chain diversity is probably one of the important things for us to consider. If I ever move out of the city, then nobody's gonna make these.
Well, if you're
making them and being compensated for it, even if it's just materials, it doesn't look right that you're approving them and then making the plaque.
And that is a fair point, sir. And here we go with quasi judicial, so.
Go ahead and snap everyone approved.
Good
Yeah.
example right there.
I mean, like I said, I offered to have, to make about 10 of them, and then that was that. But we probably should figure out, the other thing I was thinking is that the high school has a mill that's substantially better than mine. Could this be something that the high school, because I believe they've got a Tormach up there, which is a very nice mill.
Wow.
And I don't have that nice of a mill. So maybe the high school could make these, and that they could be part of the program or whatever.
That'd be so cool. And stamped at the Inglewood High School. in the back.
And you can stamp it, and not only is it, I mean, obviously this is made mostly in Inglewood here. My workshop is not in Inglewood, but, that would be neat, I don't know, selling point is, hey, the plaques are actually made by Inglewood high school students.
It's pretty cool. Well, that's.
You have the program, don't you, Matt?
What's that?
You have the program.
I have the G code for it.
Yeah.
Depending upon that, but it's calibrated for my machine, so it would.
Oh, yeah.
I would have to work with whoever there to modify the code, so it would work with their machine.
Great. Anything else? I don't mean to rush you, but we're close to time, which means we have to take a vote if we hit
That's
time. Okay, thank you. Melinda, anything for Commissioner's Choice?
Not really. I checked, and that house on Fox was built in 1900. So, just as a matter of interest. All right.
Thank you.
That's all.
Thank you. Lauren, last but not least, anything for Commissioner's Choice?
Nothing for me.
Okay. Is there a motion to adjourn?
Motion adjourned.
A second.
Second?
All right, it's been moved and seconded. We'll be in adjournment at 8:28.
Yeah, all right. Thank you, everybody. Thank you, Sergio.
Thank you.
My pleasure. Yeah, Sergio.
Bye,
thank you
everyone.
very much.
Ooh, what's this story?
You
just bought it new?
My mom gave it to me when I graduated law school, because I used to carry around a dingy bag that had a hole on the side.
Where'd you go to law school, Sergio, remind me?
EU.
Okay. I went to undergrad at EU, went to law school at CU.
Okay. No, I meant Brandon. He told me that you guys golf.
Yeah, yeah.